federal political parties have lost their bid to keep control over voter information data following a British Columbia court ruling. They had argued that the BC Privacy Commissioner did not have the power to force the parties to turn the data over, but the judge disagreed, citing an individual's control of their personal information as fundamental and a value of democracy. The ruling says the parties are subject to the investigative powers of the province's privacy commissioner. The decision could force political groups to publicly reveal how much information is gathered about Canadian voters. Well, the case began when 3 BC citizens petitioned federal parties to release data on individual voters. They also started a follow-up complaint with the province's Information and Privacy Commissioner. Andrew Clement is one of the 3 complainants. He's also a professor emeritus at the University of Toronto, and he joins us tonight from Salt Spring Island in British Columbia. And here in studio, Young Park is the lead counsel representing the complainants in this case. He is also a partner at Fogler Rubinoff. Thank you so much for joining us. Young, I'm going to get you in a second, but Andrew, I first want to ask you, what sparked you to embark on this journey, this legal journey, and to complain against the federal parties?
And concerned as a computer scientist in the way that computerization has meant that so much of our information is now loose out of our control and available to many others to use in a relatively unfettered way. And it particularly concerned me that political parties, unlike other organizations in Canada, basically had free reign with our data. They're not covered by any privacy law. And so I thought that was an important case to follow. Yeah, so I contributed.
What do you think the risks are here to voters, particularly with us not knowing how much information or what information federal parties have on us?
Well, I think the Cambridge Analytica scandal from 2018 really revealed how parties are using, this was in case in Britain, but I think it's more general, are using deeply personal information to develop psychographic profiles, to target individuals with messages that they've concocted to appeal to you or to discourage you from voting, either way. So there's just an enormous amount of power there that resides in that data, and we need to better regulate that.
Young, this is a landmark decision. We'll talk about it in a moment. But what do you think of the 3 political parties? Why do you think that they all came together on this one?
My view on that is all of them have developed very deeply personal profiles on voters. They are known to have voter relationship management systems and to use certain software for that. And so they want to continue to continue their practice of developing these profiles on voters, and so they want to do that behind the curtain. And until the landmark decision that was released this past Tuesday, they've been allowed to do so.
So talk to me a little bit about that decision and what kind of precedent that you hope that it really sets.
Well, it is a precedent that applies only to BC. Right. BC's privacy legislation applies to the provincial political parties. That's never been in dispute. What was in dispute in this case, because the complainants like Professor Clement made a complaint to the Office of the Information Privacy Commissioner with respect to the federal political parties. The question was whether or not the Privacy Commissioner had jurisdiction over them. And so the ruling confirms, because the political parties at the federal level had said constitutionally BC's privacy legislation should not apply to them, and the court disagreed. And so this is the first jurisdiction in Canada where valid privacy legislation has been held to apply to provincial parties, to federal political parties, and so it is a landmark decision.
What message does it send to the federal parties here? And also, what were the federal parties arguing? What was their defense?
Their defense was constitutional. They took the position that applying BC privacy legislation to their personal information practices would be contrary to and conflict with the Canada Elections Act, which they said gave the Chief Electoral Officer the final decisional authority over all of their practices, including their privacy practices. And so that was a constitutional argument that they advanced. But again, this court disagreed with them.
Andrew, what do you think these parties, other than target you, can do with your data, and what made you so uncomfortable with the parties having this much information on you? And I guess you still don't know how much information they have on you.
No, we don't know how much information they have on us and what they do with it, how they use it, who they disclose it to. So that's a fundamental issue right from the start. But as I was saying, that if they're not, if we don't have a better idea of what they're doing and they're not accountable to any authority, it's basically open season for them. And I'm concerned that they'll use it manipulatively, that it can be used for creating deep fakes that appeal to you, various things like that.
We are, possibly heading into an election in a couple of years. Do you think enough Canadians are paying attention to this issue?
Well, I think, sadly, no. I mean, in part, it's a complex issue. There are so many other issues that people need to be concerned about. But this is matters for our democracy. And right now, there's a significantly lower trust in our institutions, and there's an erosion of democratic practices that should be of widespread concern. And I very much hope that this can be resolved before the next election, and in particular that the parties come clean on their practices.
Well, and we'll talk to you, Young, about that in a second, but do you first worry that there's going to be an appeal by the federal party, sir?
I fully expect that there will be an appeal.
Yeah.
I'd be surprised if there wasn't. The federal political parties have expended extraordinary efforts to avoid the jurisdiction of the BC Privacy Commissioner, and so it would be surprising, even with this decision, that they would forfeit that campaign. And so our expectation is that they will appeal this decision.
So to Andrew's point, do you think by the next federal election, voters will know how much information federal parties have on them?
It's difficult to say.
Yeah.
If they appeal to the BC Court of Appeal, even if we succeed on that appeal and have this court's decision affirmed, the political parties will have the option of seeking leave to appeal to the Supreme Court of Canada. And if they pursue that option, whether this gets resolved before the next federal election is in my view, but dubious.
Andrew, last word to you. Why is this issue so important in a democratic society like Canada's?
Well, because it goes to fundamental questions of how we can participate in elections in a way where we can be confident that the parties are using our information responsibly, they're not using it to manipulate us, and the fact that they have dragged this out and are so resistant to the idea that they should become under a privacy regime is extremely worrisome, because it suggests that they are doing things with our information that they really do not want to share with us, and so that just that resistance alone, I think, is concerning.
Yeah, really important issue. There may be more developments ahead, and hope that you both do come back if there are. That is Andrew Clement, one of the three complainants in this case, and Young Park, the lead counsel. Our thanks to both of them.